we are excited to start offering probate services in Lawton, Oklahoma. Finding the right probate attorney. When it comes to probating a loved one's estate, it's very important to find the right probate attorney to ensure that the administration is carried out in the most efficient and effective manner. You don't want to waste time and you don't want to waste money. If you are an heir, you most likely have not had to experience the pain of a probate process before. Probate law is the process of administering a deceased person's estate, your loved one's estate, and it involves the distribution of assets to the rightful heirs or beneficiaries. This process is necessary to ensure that the deceased person's wishes are carried out and that their assets are distributed according to their wishes. Probate law is complex and often lengthy process. It can be helpful to have the assistance of an experienced attorney who is familiar with the intricacies of probate law. The attorney will be able to provide advice on the best course of action and help ensure that the estate is handled in a manner that is consistent with the wishes of your loved one. Most probate attorneys will provide a free initial consultation to go over the information. A lot depends on whether there is a will, a trust, or whether they did zero planning at all. The types of probates in most jurisdictions. There are generally two types of probate. One is called a summary probate proceeding, and the other, for lack of a better word, is a regular probate proceeding. There are specific requirements for summary probate, and this procedure cannot always be used because those requirements have to be met. Summary probate. A summary probate can be used when the total assets are under $200,000 here in our state, and it takes a minimum of 45 days to complete. That requirement can vary from state to state. Depending on the court's schedule, summary probate is usually completed within a couple months, probably 50 to 60 days. It can be a great alternative when the estate is small, real estate does not need to be sold, and all of the family is getting along through the probate process. That's very, very important. In order to file the initial petition for probate, all the heirs must agree in writing to move forward with a summary probate administration. If just one person disagrees, then the probate cannot proceed as a summary probate. If the beneficiaries start fighting with each other or cannot agree on certain aspects of the probate proceeding, then the probate court will a lot of times require that that summary probate be converted to a regular, longer probate. Real estate cannot be sold during a summary probate. This is because in summary probate, the legal heirs, the beneficiaries, are not determined until the end of the proceeding, at the end of that 60 days. In order for real estate to change hands, there has to be legal parties who can agree in writing. If a court does not determine the legal heirs until the end of the probate, then there is no one during the probate to legally sign a deed to transfer the title to a new buyer. Summary probate is a great tool in special cases where the estate is small, there is not going to be any litigation from family fighting, and the real estate does not need to be sold. That's key. Family fighting and not selling real estate. Regular probate. A majority of probates are administered in long form, and they take several months and even years if, again, the parties are not agreeing, the families don't agree. The attorneys will first determine if there is a last will, a pour-over will, or no last will at all. If the decedent died without a last will, this is called dying intestate. The lawyer will draft an initial petition for probate, just like in the summary. If the client agrees with the wording, then the law firm will have them sign the petition and will file that petition for probate with the court clerk. The court will order that the petition be heard at some future date, usually at least 30 days in the future. Probate lawyers will publish notice of the hearing in the local newspaper and will mail a copy of the notice of hearing to all interested parties. This is usually done by certified mail so we can prove that they got it. At the initial hearing, the court will usually make 4 determinations at that first hearing. Number 1, does the district court have jurisdiction to hear that matter? If the decedent did not live in or have assets in that county, then the court might not have jurisdiction. Number 2, is there a valid last will and testament, and should it be admitted into the probate? Number 3, who should be the personal representative of the estate? They'll actually determine that. This is sometimes called the executor and is usually the person who hired the probate attorneys to file the petition. Number 4, who are the legal heirs, sometimes called beneficiaries, of the estate? Once the court has made those 4 determinations, it will appoint the petitioner as the personal representative. This person is charged with administering the estate of the decedent. This involves gathering and identifying all assets, settling claims, administering the estate, and finally distributing what is left to to all of the heirs. Creditors usually have 60 days from the filing of the notice to creditors to file a claim against the estate. Depends from state to state. The notice to creditors is published in a local newspaper in the county where the probate is being administered. Notice to creditors is also mailed to all known creditors of the decedent, again, usually by certified mail. If a creditor files a claim against the estate, then the personal representative decides if it is valid and should it be paid. That claim then must be approved by the court before any payment can be made. A general inventory is usually required to list all of the estate's assets. This list usually includes what is in the estate: personal property, mineral interests, real estate, financial accounts. When real estate or personal property needs to be sold to satisfy debts or to make money available for distribution, the personal representative will make an application to the court for authority to sell real estate or dispose and sell personal property. Again, the judge must approve it. Earlier, I stated that the court determines the legal heirs of the estate at the first hearing, at that initial hearing on the petition. Because the judge has made that determination, all the beneficiaries must agree in writing to sell real estate or personal items by the personal representative. They have to give the personal representative permission. If they do, then the executor usually sells the house with a realtor and deposits the proceeds into the estate bank account. This is a separate bank account. Once the personal representative has gathered all of the assets, paid and settled all claims, then and only then is the estate ready for closing. This is usually done by a final account. You guessed it, another pleading. Notice of that hearing for final account is published in the newspaper, mailed to all interested parties, again by certified mail, and usually set for some future date, 30 days into the future, again, depending on the court's schedule. As you can see, if everything goes perfect, a probate will take 4 to 5 months. They never go perfect, and they usually last 5 to 7 months. If the family starts fighting, then it might take even years to complete a probate. We have had that happen on a regular basis where the family just can't get along, and it just takes years because it's hard to get onto a judge's schedule. So the best thing that you can do is to get along with your family. Common questions about probate. What are the most common issues that arise during a probate? The biggest issue during probate is the family fighting over assets. I've mentioned that several times. It's usually not even about money because there's a finite amount of money. They all know what there is. The biggest fights, hands down, involve personal items. For example, who gets that painting that's been over the fireplace for years? That painting usually is a family heirloom, and it can be a source of contention between the siblings. It can be difficult to decide who should get the painting, especially if it has been in the family for generations and generations. But with the right team, the situation can actually be done without fighting and suffering between the family members. Everybody has to get along. However, despite everyone's best efforts, fighting over personal items often is the biggest expense to an estate. You just don't fight about it. You have to go to court, and that's expensive. Hearings before judges, motions before judges are expensive. What is the best way to avoid probate? The best way to avoid probate is to decide all of these issues ahead of time before you pass away with a revocable living trust centered estate plan. You know that's my favorite. A revocable trust is a legal arrangement where a trustee holds and manages assets for the benefit of one or more beneficiaries. A testamentary trust can also provide asset protection to the beneficiaries as part of a revocable living trust estate plan. It will also provide protection for you during incapacity, avoiding costly and stressful guardianship or conservatorship hearings. The assets in a trust are not part of the probate asset, so they are not subject to the probate process. They are their own entity. Another way to avoid probate is with transfer on death designations. These are sometimes called, or you'll hear them referred to as TOD or POD, pay on death. A TOD designation is a legal mechanism that allows an individual to transfer ownership of a certain asset, such as bank accounts or securities, to a designated beneficiary upon their death without having to go through the probate process. So think about a bank account. If you have a trust, then you should consider creating a pour-over will. This type of will, a pour-over will, allows assets that were not transferred to a trust during the person's lifetime to be transferred to the trust after death. It's kind of like a backstop. Unfortunately, a probate will still be required for assets not in trust, but it allows those assets to be distributed according to your wishes to the terms in your trust. Review, and update all beneficiary designations on retirement accounts, life insurance policies, and other assets that have beneficiary designations to ensure that they line up with your overall estate plan. Very important to review them on a regular basis. It's important to know that estate planning does require a certain amount of investment in terms of money and your time, but it can save significant time and money and stress for you and your heirs in the long run. An estate plan that avoids probate can also help ensure that your assets are distributed distributed according to your wishes and in a timely manner, which can provide peace of mind for you and your loved ones. What are the consequences of not going through probate, of not going through the probate process? First, without a court-supervised probate process, it can be difficult to determine who the legal heirs of the deceased person's estate are, who gets your loved one's assets. This can lead to disputes among family members or other potential beneficiaries, which can prolong and complicate the distribution of assets. People who don't do this, and eventually do, end up costing a lot more money. Second, without probate, the deceased person's creditors may not be notified of their death and may continue to seek payment of debts. This can result in assets being unnecessarily tied up in debt repayment rather than be distributed to the rightful beneficiaries. Third, not going through probate can result in delay in the distribution of assets to the beneficiary, as there's no legal process in place to ensure that assets are properly accounted for and distributed in a timely manner. This is especially true with real estate. There has to be a legal process to transfer it. Fourth, if the person owned real estate, it's not possible to transfer the title of property without probate. Now, you can do deeds during your lifetime, but if you don't, you have to go through probate. Lastly, if the deceased person had any outstanding taxes, those taxes still need to be settled. Overall, going through the probate process can help ensure that your loved one's assets are distributed according to their wishes, not to some other family member's wishes, and that any outstanding debts and taxes are paid so that the beneficiaries can receive the inheritance as soon as possible. What are the steps involved in the probate process? Probate is a legal process of settling a deceased person's estate and distributing their assets to their heirs and beneficiaries. It can be a lengthy and complex process depending on the size of the estate and the number of the beneficiaries. The executor of the estate is responsible for gathering all of the deceased assets, including real estate, investments, bank accounts, and personal property. They must also pay any outstanding debts, such as credit card balances, medical bills, mortgages, and other personal loans that they may have. In addition, they must identify and locate all of the beneficiaries of the estate and distribute the assets according to the deceased person's wishes or according to the state's laws of intestate succession. This can be a complicated process as it requires the executor to locate and identify all of the assets, determine the value, pay outstanding debts, and then divide the remaining assets between the beneficiaries that they have found. The average time it takes to complete a probate case is usually 4 to 7 months. It's important to know that the executor is responsible for ensuring that the wishes of the deceased are carried out. That's the goal. It's important to ensure that all the necessary paperwork is filled out in a timely manner, as failure to do it correctly can result in serious consequences and costly legal battles later on. What are some of the common mistakes people make during probate? Some common mistakes people make during probate include failing to properly identify and collect all assets, failing to properly value the assets, failing to properly pay debts and taxes, and failing to properly distribute the assets to the beneficiaries. One of the first mistakes is not knowing whether the deceased person, whether the loved one died testate, meaning they left a valid will, or intestate, meaning they did not have a will at all. Very important. In case of testate, the last will must be located and filed with the court, and the appointed executor must be qualified to act in such a capacity and follow what's in that will. On the other hand, in case of intestate, dying without a will, the court will appoint an executor to oversee the distribution of the assets. Another mistake is not identifying and collecting all assets of the deceased person. This is very important. This includes not only the physical assets like real estate and personal property, but also bank accounts, investment accounts, and insurance policies. Sometimes it's hard to locate all of those different financial instruments. Additionally, many people fail to properly value the assets in the probate. This is especially important when it comes to assets that are subject to fluctuation in value, such as stock and even real estate these days. This can lead to assets being undervalued, which can affect the distribution of assets to the beneficiaries. Failing to properly pay debts and taxes is another common mistake. This includes not only outstanding debts, but also taxes that may be due, such as estate taxes and even income taxes depending on when they died. Lastly, failing to properly distribute assets to beneficiaries is also a common mistake. This can occur when beneficiaries are not properly identified. You don't know who they all are, or when assets are distributed in a way that does not comply with the terms of the will or state law. law. The best thing you can do is call a probate attorney in your state, in your city, and ask them for help. You will be working with your probate attorney for several months, so it's best to interview a few different law firms, few different attorneys, and find somebody that you're comfortable with to help you through this process. I know I've thrown a lot at you today, so that's why we've prepared our free guide on estate planning. I'll put a link to it in the description below and in the comment section below that so that you can download it and get started in the right direction. And to help you out even more, watch this video up here and this video up here. If you enjoyed this video, then guys, please smash that subscribe button and click on the like button. And also click on that little bell so you'll get notified every time we post a new video. Have a great day and an awesome week. And as always, thanks for watching.